I'm going to begin the Radnor Township Zoning Hearing Board for Thursday, June 21st. We have a request for two continuances, and it's Appeal 2877, the applicant to Radnor Fire Company and Metro PCS, Pennsylvania.
Good evening, members of the board. Nicholas Cuchet here on behalf of Radnor Fire Company and Metro PCS.
Okay. I have a from Mr. Kachansky. Please discuss at the township request. Please note the applicant requested continuance from the June 21st, 2012 zoning hearing board hearing and further request to be placed on the July 19th, 2012 zoning hearing board agenda. Please note that the applicant waives all requirements of the Pennsylvania Municipalities Planning Code that pertain to hearing timeline mandates. Please note that this waiver is in effect until July 20th, 2012. Finally, this letter confirms the waiving of the zoning hearing board's continuance fee for this continuance. If you have any questions or concerns, please feel free to contact my office. Mr. Nicholas Cuchet, sorry.
That's fine. Yes, in fact, I was in contact with Mr. Kachansky. The Radnor Township requested that the applicants continue this particular hearing date to July in order to confirm that all alternatives for this particular installation have been exhausted, as well as discussions regarding potential style of the proposed tower.
Okay.
In your letter, you talk about extending the time periods for hearings. I believe it's necessarily implicit, but would you confirm for the record that you would grant the extension for the commencement of the 45-day to the rendering for the rendering of a decision under the MPC? Confirm that that does not commence till the closure of hearings.
Yes, I will confirm that, Mr. Ryan.
Any questions, Noah? No. Jim?
No question.
All right. Okay. You also we were handed up an amendment to price. Okay, and we all have that. Yeah. Okay, that'll be entered into the record too.
Thank you very much.
Are these to be entered into the record as exhibits now, or at the hearing?
No. Why don't we do it then? Because they may have something change between now.
That's
and July.
exactly what I was wondering.
Yes. Yep. Okay. Okay.
Thank you all very much.
Mm-hmm.
Thank you.
Appeal 2881. If anyone is here for the Metro PCS, you can go home or you can stay here and listen to the rest of the evening. Appeal 2881, applicant Goshen Holding Company, LP, property located at 800 Goshen Road, Lot 9, zoned R1. Applicant seeks the appeal of the Township Zoning Officer granting applicant denial, dated April 5th, 2012. This is also a request for continuance?
It is. We submitted a letter to Mr. Ryan to that effect.
And extending properly extending the time for the decision.
That's correct. That was set forth in the letter as well.
Yeah. Dear Mr. Ryan, as per our conversations, Goshen Holding Company, the applicant in the above referenced zoning hearing board appeal, hereby request a continuance to the scheduled June 21st, 2012 hearing. We request that the hearing be continued until the regularly scheduled July hearing. Accordingly, we hereby grant the zoning hearing board an extension through July 31st, 2012 of the 60-day time period within the zoning hearing board must hold initial hearings on the subject application. The applicant further recognizes and grants a correspondence extension to the zoning hearing board of the date upon which time period pursuant to the zoning hearing board must issue its decision begins. If you have any questions or need any further information, please feel free to contact me, Dave Falcone.
That's correct.
Any questions? Don't say it, Noah.
I have no question about the continuance. However, I do have a question about this case because I'm sure everyone's aware, including you, Mr. Falcone, we received some letters from a neighbor objecting to this, and he said he would not be able to attend this hearing. Now it's convenient because I guess he will be able to attend the next one. It may not be convenient for you, but I'm not sure, are we supposed to take any notice of those letters? They were not submitted under oath. The man's not subject to being cross-examined. What weight are we to give those letters, or are we to disregard them?
Well, I think that there's two questions. One, do they get in at all? And second, is there any weight to be attached to them? I think that for signaling opposition, a signed letter can get you into the record as, and they can be objected to, of course, but I think, a signed letter is enough to get a person in as a party subject to objections and so forth. That doesn't do very much if you're not there to be cross-examined. And I personally would advise the board to give, if a person's not here to be cross-examined and participate, I think that that's goes to how much weight the letter should be. What we do not do is allow unsigned emails or things of that sort for any purpose whatsoever.
I note that some of these letters do allege facts.
Yeah.
And I think certainly the applicant should have the right to question the
Or object to
signer.
them. I mean, they haven't been put into the record yet.
And we have not seen them, Mr. Cutler.
You don't have those letters?
No, sir.
Aren't they sent to the applicant as well?
I'm not sure how they came in. I'd have to go back and take a look at that.
I got them by email from the township, I believe, Sally, or from John, maybe both. Some of them I got duplicates.
Yeah,
I don't want to get involved in this conversation, so I'm going to kind of stop and
That's fine.
let Jim get involved.
I think in any event, we can deal with this. This is an evidentiary question we'll deal with at the hearing if we grant the extension. I don't think we need to deal with it now, the letters on objection. Does anybody disagree with that?
I just think that somebody ought to let the person who wrote the letters know,
Okay.
if we're going to disregard them, that he needs to show up next time, or his voice will not be heard by
Okay.
this board.
Can we take care? Kevin? Can we take care of that?
Yes, I can reach out to the author of the letter and let them know that.
Yeah, I
it was
wouldn't reach out to
continued.
him today because he said he was away and now he
Right.
can't make this meeting. But sometime, well in advance of the next meeting, I think someone should let him know.
And I would certainly love a copy of those letters.
Yeah, and would you mind sending copies of the letters to Mr. Falcone?
Sure, I apologize that was not sent to you. And if they came in via email, I can send an email to the author and let them know.
Thanks.
I think that there is if one wishes to participate in one of our decisions, it behooves one to be here and not just send letters.
Right, agree. And I think we've made that clear in
Many,
previous
many
hearings.
times.
Yes. Does anybody have any questions or comments regarding the requested extension? Anybody have any objections to the requested extension? All in favor of granting the requested extension?
Thank you.
It'll be to the July hearing, third Thursday in July.
I believe it's July 19.
Thank
Anything
you.
else?
Nope, see you in a minute.
Thank you.
And again, if anyone is here for that hearing, you can go home, or you can stay here. If your air conditioner is not working, it's probably cooler here than it is at home. The next one is 2882, the applicant PNB Bank National Association, property located at 550 East Lancaster Avenue in Zone PB. The applicant is seeking release from Section 280-123B of the Code to permit the installation of 3 wall signs to identify the PNC Bank in the St. David's Square Shopping Center.
Good evening, Mr. Chairman. Rob Lewis from Kaplan Stewart, representing the applicant. As an order of house cleaning, unfortunately, there's a typo. It's PNC, not PNB. PNB, I don't think, has been around for quite a while.
Excuse me, sir, before you start, there's a point of information that would be useful to have, and I didn't see it on the plans. Do you know what the dimensions are of each of the building sides?
Excuse me.
Is that on a plan that I missed or something?
I'll have to have my engineer answer that question, Mr. Cutler.
Because part of our computations relate to the the frontage of the building, the sides of the building?
I believe that the ordinance provision actually simply permits a maximum of 60 square feet because of the...
No. It says not exceed 2 square feet for the first 15 linear feet of building frontage, plus 1 square foot, et cetera, up to a maximum of 60. So it would be the lesser of the two, plus if you were to get a variance to put it on 3 sides, the question is how much of a variance really is that? We don't really know unless we know what these frontages are.
My engineer will take a look at the measurements, and if we need to, we will scale it off of the existing plan. Is this the scale? Yep. As we're waiting that information, would you like me to start, Mr.
Sure.
Mr. Chairman, are we okay?
Yes, please begin.
Good evening again. My name is Rob Lewis from Kaplan Stewart, and I represent PNC Bank, who is the applicant this evening. They are the lessee of a portion of the St. David Square Shopping Center. The property address for the shopping center is 550 East Lancaster Avenue, which obviously is right around the corner from where we are this evening, the Gennardi Shopping Center. Included in our application, I believe as Exhibit B, is the deed to the owner of the shopping center, which is KMO 361 Realty Associates. They actually also are our client. And also attached to the application is the redacted lease to PNC, and you'll see specifically in that lease KMO's authorization to PNC to seek approval of the signage that's the subject of this evening's hearing.
Where is that in the lease, Mr. Lewis?
It is in paragraph or section 8.4F of the lease, referencing the attached exhibit signage. The proviso in the lease actually says that it shall not delay the opening of the bank branch, but it actually references the attached
But is there an
signage
authority
proposal.
to make this application?
That is the authority granted by KMO.
John, do you think that's authority?
I saw something that was different that did give that authority.
It's
How's that?
8.4A talks about the signs, but it doesn't give an authority to apply for variance. And I don't see F as giving authority. I see F is
No,
saying
there's
that
something else I saw in
that the
here,
landlord
flag.
approves certain signs.
Submit to the board that the landlord has approved the proposed signage and thus has given the authority, and also on behalf of my client, KMO, I have been instructed that they have the authority, so I can represent our client, KMO, in that respect as well. George Brosman from my firm represented KMO throughout the entire land development process before your Board of Supervisors, and in fact, we were required to obtain a waiver of conflicts in order to represent PNC this evening. So we do represent both the landlord and the tenant.
Mr. Cutler, I would actually look at 8.2B on page 27, bottom of that provision.
27?
Page 27 of the lease. This is a two-sided copy of the lease. And what I saw, tenants shall not have the right to seek any variances other than those required for the construction of the project in accordance with the plans and specifications paren, as opposed to sign variances. Now, that's kind of a backhanded way of doing it. But
I don't think that's authority. I think it's a limitation of authority.
well, I think that.
Well, I'll be guided by you. I just want to make sure that this party has standing, and therefore we have jurisdiction to hear the application.
If I would like to see it a little more clearly stated, but on the balance, I'm comfortable that they have authority be coming in here for these signs.
Then
These are the signs that were approved by the landlord in the exhibit.
That's correct. They
So,
are
yeah, they
the
haven't
signs that
changed.
are. They have not. In fact, the sign package that's attached to the lease is more extensive because it does include directional signage that we're not seeking relief for, as well as some of the minor window signage that is not governed by the ordinance, FDIC insured, ATM signage, things that are not requiring relief. So that is all attached to the lease.
John, do we want to mark these?
I think
Exhibits?
I think we ought to,
Okay.
actually.
Why don't we, we'll use, how about we use their,
Well, there are a couple ways you can.
we can use his Exhibit A as 1, and B, C, D, and E.
Why don't we? Do you want to do the application as A1?
Okay. And then Exhibit A will be A2, which is the lease.
Okay.
Exhibit B, which is the deed, is A3. Drawing sheet 3 of 16 will be A4. D, which is the signage zoning plan, will be, what will be, A5? And Exhibit E, which is
Bowler drawings.
with the building elevations,
Okay.
is A6. That's all of them?
I think you were going to introduce the CV of your engineer,
I
project
am.
manager.
And we'll mark that as A7.
Okay. I'm the only person who has this. They probably ought to be handed up to the rest of the board.
I need two, could I get two from, one I can use and one I'm going to put as the file. So we have 7 altogether, right, John?
Correct.
I will, ultimately, I will mark
You have more?
applicant's exhibit A8 as well.
Okay.
Would it, okay.
For A8, we only have a full-size copy, but I will submit that.
What is A8?
A8 is an exhibit that Mr. Britz will testify to. They are photos of the site. It's referred to as a sightline exhibit, prepared by Bowler Engineering. It is dated April 27th, 2012. And its sheet title is Sightline Exhibit.
Okay, that'll have to be left with
Yep.
the record.
It's foldable, it's not.
Yeah, I was going to say,
permanent.
you don't need the hardboard, just give us the foldable one, and we'll make that, we'll put that in the
I was
official.
hoping we get the cardboard, too.
I don't think it's going to fit in his drawer. Okay, go ahead.
Can we, thank you. The PNC Bank branch that we're here to talk about this evening was actually approved earlier this year by the Board of Supervisors. I don't intend to go into the full aspects of that land development process, but suffice it to say that it was a long-term cooperative effort between the Township, PNC, the shopping center owner, as well as a number of the adjacent residences. We're here this evening not regarding any of the land development aspects of the center, but PNC's signage. The shopping center, and most importantly, the bank pad portion of the shopping center that we're here about this evening is in the PB Planned Business District. Under the PB District, generally speaking, once you meet the threshold, as Mr. Cutler has pointed out, the maximum permitted signage for any one business is a single wall sign not to exceed 60 square feet. As Mr. Britz, my engineer, will testify to this evening, PNC Bank is not an inline space, as may be more typical of this shopping center. that might only have one frontage and one area with which it needs to direct attention for vehicular or pedestrian traffic. Rather, the PNC actually has traffic approaching essentially from all four sides. Unfortunately, as Mr. Britz will point out, one of our sides is occupied with a drive-through. So what we are seeking to do is to identify two vehicular and pedestrian traffic from the three remaining sides. We are proposing a total of three signs, each measuring 46.35 square feet for a total of 139.05 square feet. Unless there are any additional housekeeping items or questions for me, I'd like to have Mr. Britz sworn and call him to testify.
Sir, if you'll raise your right hand, I'll swear you in. You do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
I do.
State your full name for the record, please,
Eric Britz,
and spell.
B-R-I-T-Z.
Mr. Britz, can you please state your full business address and with whom you're presently employed?
I'm employed with Bowler Engineering, Inc. We're located at 1600 Manor Drive, Chalfont, Pennsylvania, Suite 200.
And Mr. Britz, I'm going to hand you what I marked and handed up to the board as applicant's exhibit A7. Is that an accurate statement of your education and your qualifications?
It is.
And am I correct that you're a licensed professional engineer in the Commonwealth of Pennsylvania?
Yes.
Okay. Based upon Mr. Britz's CV, which has been marked as A7, and his licensing as a professional engineer in the Commonwealth, I would submit and request that he be admitted as an expert in civil engineering. I'm more than happy to ask him additional questions.
No, I don't think that's necessary. Anybody? No? Okay. Hey, Jim? Fine, no problem.
Thank you.
You look like an expert.
Eric, on the table in front of you is a plan that was attached to our application and has since been marked as applicant's exhibit A4, entitled Overall Proposed Plan, Sheet 3 of 6, prepared by Site Engineering Concepts, LLC. Are you familiar with the plan that has been marked as A4?
I am.
Okay. You did not prepare A4, correct?
That's correct.
Okay. Utilizing what has been marked as A4, can you just very briefly describe for the board the property that's the subject of this evening's application?
The property is located at 550 East Lancaster Ave, Route 30. It's a shopping center just west of Ivan Ave in Radnor Township. It identifies a proposed bank that was approved a few months ago and some other minor improvements on the site.
Can you describe for the board briefly on this plan where Lancaster Ave is and where the access points to the shopping center are?
Sure. Lancaster Ave runs along the top of the page. Ivan Ave along the right-hand side of the page. You got access. You got two signalized access points along Lancaster Ave. One on the east side of the property, one on the west side of the property, and then and from those access drives, you gain access into the pad site internally, behind to the south of the bank. One on the east side of the property, and one also on the west side of the property.
And so am I correct that there is no independent access to Lancaster Ave from the PNC Bank facility?
Yes.
Okay. Eric, the board previously marked applicant's exhibit A5, which is a plan prepared by Bowler Engineering entitled Signage Zoning Plan Sheet 1 of 1, dated April 27, 2012. Was this plan prepared by you or at your direction?
Yes.
And you're familiar with the contents of this plan?
I am.
This is which exhibit?
A5.
A5. Thank you.
Utilizing A5, can you briefly describe the PNC Bank pad site and the locations of the signs that are the subject of this evening's hearing?
Okay, the pad site is located on the east side of the shopping center parking lot, to the south of East Lancaster Ave, and to the west of the existing drive aisle, closest to the bank, and to the north of the retail center.
And does Exhibit A5 depict the proposed locations of the signage that's the subject of this evening's hearing?
It does.
And can you point those out for the board?
Sure. We're proposing 3 channel letter signs, one on the north face of the building, one on the west face of the building, and another one on the south face of the building.
And in the lower right-hand corner, is that an accurate depiction of the proposed sign in each of those locations?
Yes.
And what's the measurement in square footage of that proposed sign?
It measures it, the tallest height is 2 foot 8 1/8 inch by a length of 17 feet 3 3/4 inch, and the square footage is 46.35 square feet.
Eric, continuing to use A5, can you describe for the board the intended audience for each of the 3 proposed PNC signs?
Sure. The northern-facing sign is really intended to capture an audience along East Lancaster Ave, coming from either direction, but mostly from the westbound traffic on East Lancaster Ave. The sign on the west face of the building is to capture an audience from eastbound traffic on West Lancaster Ave and also from the access drive, and mostly from the access drive within the center to the west of the bank. On the south face is to capture an audience from the south of the bank, obviously, mostly from this intersection at the south of the center, really to notify patrons as they come into the site that the bank is located at that spot.
Eric, I'm going to place on the table in front of you plans that were marked by the board as applicant's Exhibit A6, which consists of 2 sheets entitled Building Elevations, prepared by Bowler Engineering, dated May 21st, 2012. Were these elevations prepared by you or at your direction?
Yes.
And you're familiar with those elevations?
I am.
And are these elevations accurate depictions of the signage that you just discussed from A5?
Yes.
Okay. Eric, I'm going to return Exhibit A5 to the table. I mentioned, and you confirmed, that the PNC Bank does not have its own access to Lancaster Avenue. And generally, we've discussed the site, but we haven't talked about what difficulties PNC faces in terms of identifying itself to its audience. Can you discuss that briefly with the board, describing any physical conditions of the property that may make it difficult to identify to vehicular traffic?
Sure. The parking lot where the bank is located is elevated above the road, and that in conjunction with the landscaping along East Lancaster Ave does make it difficult for identification of the bank building.
Okay. Eric, have you performed any kind of analysis or prepared any materials for the board to demonstrate some of the sightline difficulties that this site faces?
I have.
And is that what I've placed on the table and marked as applicant's Exhibit A8, a plan entitled Sightline Exhibit, Sheet 1 of 1, dated April 27th, 2012?
Yes.
Can you walk the board through each of the 4, I'll call them photographs, but I'll let you describe what it is, and describe for the board the challenges that are faced with each of those angles of approach?
Sure. View 1, View 1 in the upper left-hand corner of the exhibit identifies the westbound East Lancaster Ave approach. What you'll see is the bank is slightly elevated. There's some landscaping, and there's a view, slight view of the signage in the front of the building there. View 2 goes into is a view directly from the intersection, showing the bank building, and where you can really just see that front sign. View 3 is a eastbound approach to the bank, and you can see the elevation of the mix of the elevation of the bank in conjunction with the landscaping. Does somewhat hide the building, but as you go through, you can kind of see the sign there. And then view 4 is a view from the back of the bank coming from inside the center, from the back of the center, and at the intersection, the southern intersection, internal intersection of the shopping center, where you can see the proposed southern facade of the bank.
And based upon your experience and expertise, you believe these to be accurate representations of the views that drivers will face when approaching the PNC from the various locations that you mentioned?
Yes.
Okay. In your opinion, do these difficulties in sight lines necessitate the signage that we're proposing this evening?
Yes.
Okay. Eric, in your opinion, if granted, would the requested relief be detrimentally impactful to the adjoining properties or in any way have a substantial or permanent impairment to the use or enjoyment or development of any of the adjacent properties?
No.
Okay. Would it be injurious to the public health, safety, or welfare?
No.
And in your opinion, is the signage that we're proposing this evening the minimum necessary to properly identify the PNC Bank to the various approaches of vehicular traffic?
Yes.
Eric, Mr. Cutler asked you earlier if you knew the dimensions of the building. Were you able to scale those dimensions?
I was. Approximately the area of the, if you would, can I look at Exhibit A6?
Yep.
I can point out which sides we're looking at. The approximate area, square footage, that we're looking at for the longer face of the building is approximately 1560 square foot, and the north and south faces are approximately 960 square feet.
What are the lineal dimensions?
What I was looking for was the length of
The
each building face.
They are, that I can give you the long face is 78. And the shorter face is 58.
And is that generally consistent with a PNC Bank branch prototype?
Yes.
And based upon your experience building and approving such sites, you believe those dimensions to be reasonably accurate?
Yes.
Mr. Cutler, does that answer your question?
Yeah, and then we'll have to do a little math. So let's say
78 by
the
58.
first 15 linear feet, it's 2 square feet, so that's 30 feet, and it's 1 after that. So it gets you up to the maximum on the long faces.
And it would only, I believe, get us to 58. No, I apologize. So, I think it would get us actually to the maximum by my quick math on all sides, if any of those sides were considered to be the sole side.
Mm-hmm.
So again, we are requesting relief actually in two forms from the same provision of your ordinance. One is to permit 3 signs on 3 facades, and the other is to exceed the maximum square footage that would be permitted, which is 60 square feet, by proposing 139.05 square feet. And again, that relief is from Section 280-123.b of the Radnor Township Code.
Does Mr. Britz have more testimony, or may we ask him questions?
You may ask him questions.
Okay. Mr. Britz, you're familiar with the site?
Yes.
Aren't there monument signs by each of the 2 entrances to the center?
Yes.
And there are listings for the occupants on those signs, aren't there?
There are.
Will there be a listing for PNC?
There will be a listing for PNC on the one sign closest to the bank.
On both sides of that monument sign?
That I'm not sure, but I do believe so.
It's a 2-sided sign, I know, and
Yes.
they're actually trans-illuminated, so they light up and you can read them even at night.
Yes.
So someone coming east or west would see that the same as they would for Bed Bath & Beyond or
Yes.
Gennardi's or something. Okay. The other question is the pad for this building going to be at existing grade level, or is it going to vary from the existing grade level?
It is going to be approximately the existing grade level. It will be slightly elevated.
Do you know what the height of the top of each of these signs is with regard to existing grade level? Will any exceed 16 feet from existing grade?
They will be, the sign on the lower face of the building will be at 12 foot 6 inches, and the sign on the front of the building will be at 14 foot 4 inches.
Now, those are the tops of the signs?
To the top of the sign, yes.
Right, okay, good. Just make sure we don't have another issue.
Eric, just to clarify, you were referencing applicant's Exhibit A6 for those dimensions?
That's correct.
I do have with me this evening
is that
also
on
a
A6?
representative of PNC Bank. I do not intend to call him for any direct testimony, but if the board had a question that they felt was more appropriate to address to a PNC representative, I would make him available to you.
This may not be
No,
directly related to the signage, but what about the traffic to and from that intersection? You know, you are talking about Bed Bath and Beyond, TJ Maxx and all. How are you going to meander that into this drive-through? You have some map?
What I've just placed back onto the table is applicant's Exhibit A5 that Eric will reference in trying to provide you an answer.
Access from the west end of the shopping center will come along the frontage of the shopping center, make a left into the parking lot area, and then a right into the drive-through lane and around. We'll have do not enter signs here. And we also, if not going to the drive-through, they would just make a left into the parking lot area and park at one of the various spaces adjacent to the bank.
Will it result in queuing? I mean, more traffic, you know, especially for the other shops coming in?
Certainly, there's the anticipation that there will be some additional traffic to the shopping center with the PNC Bank. Those were matters that I'm sure were discussed during the land development process, but there certainly will be some additional traffic.
Yeah, that really doesn't impact the signage or isn't impacted by the signage, is it?
It is, but you are talking about the hardship part of it, because the community may impact, because the traffic coming to the other two developments will be impacted by the traffic getting into the bank.
The development's approved. The development has been approved.
Yeah, but we are approving the signage, or we may approve, but it has an impact on the community. If the signage is not there, probably they won't come in this direction. They will come only from the other western side.
Mr. Lewis, a couple of quick questions. When has final land development approval issued on this, or preliminary?
I know that there has been preliminary land development approval. I do not believe that the plan has yet been recorded. Eric, do you know better than I?
I do believe it's been finally approved. It was quite a few weeks ago that we were talking about kicking into construction. They were waiting for the agreements to be set in place, but I'm not 100% sure if the agreements have been finalized.
And Mr. Ryan, actually, the applicant's Exhibit A4 is signed by the owner of the property, indicating to me that it was the copy that I attached to the application was in the process of being recorded. If it was signed by the owner,
Do you know if this has gone through the preliminary and final approval stages in terms of resolutions?
It has, yes.
When was the final resolution?
I do have that date. I apologize. 1 second. I believe it was May of this year, but.
Kevin, do you have those drawings? I have a question to ask. Where is this? Never mind, right? Do you have these drawings, Kevin?
No, I do not. You have the packet.
On On the west elevation, they have, it looks like a canopy or an awning. Could they technically move one of those signs on that and call it an awning sign, therefore they give them relief from the side sign? Because 122 says, 280, 122, definition of an awning sign. An awning sign shall be permitted and shall be included in the computation of the total permitted sign area. So they'd have to still meet the sign area requirement. The sign shall display only the business name, proprietary, which is what they have. And it's got to be vertical and within 14 inches from the base of the awning. But would that take care of one of the sign sides? I think it would, because if they put it on an awning, you can have more than one facing. An awning doesn't count as a side, I believe.
Doesn't count as a wall sign.
Doesn't count as a wall.
I'm not sure which overhang. If you're referring to the drive-through, I would not.
No, it's not. It's,
Okay.
not, it's on the west end. The drive-through's on the east end of the building.
I'd have to
There,
take a
right.
look at that, but there is a possibility that that could be considered an awning.
Right.
And if it would be, then they'd be permitted to put an awning sign on top of that.
Well, there's a definition in the ordinance of awning sign. It says, any sign painted on or applied to a structure made of cloth, canvas, metal, or similar material which is affixed to a building and projects therefrom. Such signs may or may not be fixed or equipped with a mechanism for raising and holding an awning in a retracted position against the building. That's what an awning sign is under the code.
Is there a limitation on illumination?
Well, there are other limitations on illumination. Do you plan to illuminate these signs?
Yes,
And how are they going to be illuminated?
internally.
Internal illumination?
Internal.
That's not permitted under the code. That's specifically prohibited. I mean, you didn't ask for a variance from that.
We did not.
So we can't give you one.
So
but
we will have to
Not
comply.
tonight. But it's specifically prohibited under 280, 119S as in Sam. Internally illuminated signs except as may be provided for within this article.
Has to be updated. Mr. Ryan, in response to your question, I might as well mark this as applicant's exhibit A9.
Yep.
It is a copy of the February 20th, 2012 letter from Mr. Rice, enclosing a copy of Resolution 2012-20, which granted preliminary final land development approval for the shopping center.
Okay, so this is 13 February.
I believe they have to be upland.
This is A9?
Yes. We'll have to deal with it. Not tonight.
Now, Mr. Britz, you said you're familiar with the site. The Micro Center building is also a freestanding building in a similar position to this one, although a bigger building. Do you know if that has signage on three sides?
That I'm not familiar with.
Could you put this in the file? This is the appellant's. It just shows the date.
Because everybody seems to find their way to Micro Center just fine. Even I found it on occasion.
We're not going to see it tonight.
That I'm not sure, though.
Realize if we find there's a hardship, which is our first situation to deal with, we have to grant you the minimum relief necessary to relieve the hardship. So I think if there's an existing thriving business in a similar situation there that's gotten by without three signs on three faces of the building, it tends to reflect on certainly whether this is a minimum relief to alleviate your hardship.
Mr. Cutler, I would submit to you every business is slightly different, and certainly, obviously, we need to try and identify to the proposed users of our center. While we are all on the same parcel and do suffer from some of the unique conditions, they may just not have deemed it necessary. So I can't speak for what they felt they needed. And you are probably more familiar with the center than either Mr. Britz or I in terms of daily use. But I think Eric testified and will certainly repeat that based upon his experience designing these sites, designing them to the needs of PNC, that we have proposed the minimum signage they believe is necessary to identify to those customers.
I have a question for Mr. Briz. How was it determined? And I don't think that you determined, but how was it determined how large the signs needed to be? I mean, how was the figure 46.35 derived? Was it fits in the space? It is derived from the view angles from the roadway. Where does that come from?
Well, first, the area is based on the code definitions, a rectangle around the large.
No, I understand how it was calculated, but how was the sign itself designed?
It's part of their standard package. PNC has a standard signage package. That's what we proposed on the side of the building.
So the standard package has signs that are 46.35
Yes.
square feet?
Yes.
Okay. So that, all right, I just wanted to know if it bore some relation to the view.
May I elaborate on that,
Sure.
Mr. Dolan? And I'll do it as best I can in the form of a question, so that it's from Mr. Britz as opposed to myself. Mr. Britz, you've mentioned that you've implemented or been involved in the approval process of a number of these PNC banks. Is that correct?
That is correct.
And then you're also, although you're not an architect, you are familiar with many of the architectural features of this building and the constraints that PNC is under?
Yes.
Am I also correct that the prototype that is being proposed here is a LEED certified building designed by PNC?
That is right.
And is it your understanding that through that architectural process, everything is considered, including the appropriateness of the signage in relation to the building?
Yes.
Doesn't sound the same if I simply say that it's a LEED certified building, that the architects have done it, but I wanted to make sure.
It's also not evidence, right?
What you're telling us is these signs are aesthetically pleasing with the design of the building.
Yes.
Okay.
Mr. Britz, do you believe that they will appropriately identify the PNC to the traffic that you discussed earlier?
Yes.
Okay. That's certainly all the questions I have from Mr. Britz. I know the board has been asking questions, but it's the only direct testimony that I have this evening.
Mr. Britz, in your estimation, would that PNC sign on the west end fall or fit in that canopy area that we're talking about? It looks like it, just by looking at it, it looks like it'd be pretty close.
It does look like it would be pretty close. I'd have to evaluate it for sure.
But if you had to make it fit, you could do that, right?
I think we could do that.
Okay. Thank you. Any questions, Noah?
What does that gain? It still goes to the maximum signage.
Well, yeah, it would be,
Reduces the number of wall signs.
it reduces the number of wall signs.
But it doesn't solve their big problem, which is they're way over the allowed signage for the
Yeah, but
property.
that doesn't necessarily, well,
I mean, that's really a distinction without a difference. They're going to have signs on three faces that far exceed the limitations.
I guess that's if we agree, if we all agree, or majority of us agree that they need 3 signs. Suppose we say they need 2 signs and one of them's that canopy sign, then the only thing they would need is a variance on the 60 square feet. And if they have to shrink this one a little bit, they may be very close to the 60
Well, I mean,
square
they're not asking us to design their signage for them.
I understand that.
We're just telling them whether they can or cannot do what they've proposed, whether we'll grant them the variances to do what they have proposed, which is 3 wall signs on 3 walls. Well, I mean, we can approve it or not approve it.
When it's your turn, you'll be called upon. Thank you. Thank you. I understand. Thank you.
The problem is the square footage area of the
Yes.
signs.
And the
That's their
number.
bigger problem.
Okay. I
Plus
agree.
the illumination.
The illumination,
The
they haven't
illumination,
asked
we
us
have
for
not
that.
requested relief on the illumination. That
So
would
there
be
won't be
our
Yeah,
responsibility to
We can't
comply
take
with
that
the
into
ordinance.
account.
Right.
No, so if a variance were granted, it would be for non-illuminated signs.
It would
Well, it could be illuminated. It can't be
Illum-
internally illuminated.
Correct.
Internally illuminated.
illuminated in accordance with the ordinance.
Yes. Okay. Jim, any questions? Mr. Britz, do you have any questions, Mr. Britz?
Yeah, I have a question. That P003 south side sign, is that required really?
South side sign.
Because you are coming from Gennady side.
Right. The sign here.
Who is going to see that sign?
That is there really to identify to anybody that's in the shopping center coming out of the shopping center, if they're down in this location, or once they pull around to the side of the entrance here to this location, south of the building, to identify what that building is.
But you have signed the other two sites, already identified that sign.
If during this approach and entering this side of the building, they don't notice these signs, if they're paying attention to the road, not the signage, they come around, it's there to notify them that, yes, the bank is here, so in case, that this is a bank, in case they're pulling around, so they don't have to come back, make a U-turn, or try to drive through the parking lot to get
They
there.
can't see the bank when they're that close?
They could see the building, but they might not
They're in
know what
trouble.
it is.
They're not finding anything.
Well, couldn't that be dealt with through a directional sign?
Because there is one there.
If you had a little directional sign right there as you approach from the uphill direction going down toward Lancaster Avenue, the building's in front of you. If there were a directional sign there on that driveway, wouldn't that deal with someone who's already in the center, moving at a slow rate of speed, seeing a bank building in front of him, and there's a little directional sign that says PNC with an arrow?
I suppose that would help, but it wouldn't have as much of an effect.
No, but I mean, the idea is not to advertise. The idea here is not advertising. It's to make sure people don't get confused and can find the bank.
Correct.
So I think a directional sign might solve your problem there and get rid of one of the wall signs, which goes a long way toward
I
solving
think the
your
board
problem.
makes a very valid point, and I think we can achieve what Mr. Cutler and Mr. Falcone are indicating and utilize a compliant directional sign in that location. And if the board was inclined to grant us the relief for the west elevation, we would withdraw our request for the sign on that south side. That would then reduce our overall square footage to roughly, I believe it's roughly 90 square feet.
Questions? Noah?
Is that agreeable that you will take off?
We would absolutely take off that south sign if the board were inclined to grant our relief on the west elevation.
Okay, thank you.
Jim?
And the north?
The north actually would be permitted by right.
Okay, so just,
I have no further questions for this
Okay.
witness.
Okay, do you have anyone else?
I do not. I do not have any additional testimony to present. I would simply ask to move for admission of my exhibits.
And you'll get us A8?
I will pull it off the
Okay,
board.
good. Anyone in the audience have anything they would like? Mr. Schneller?
Yes,
Now you can talk.
thanks. Pardon my interruption, I was concerned being left out.
Mr. Schneller, you'll need to come up and use the microphone when they, you know.
Oh, by the way, I should let you know, there are some provisions that allow some window signs, too, that don't go toward the total, including permanent window signs. So if you take advantage of some of those, you might be able to also solve your problem with some of that. Something to think about.
Mr. Schneller?
Yes,
You want to, your address, please, see if I can determine whether you have standing in this matter?
my address is 430 East Lancaster Avenue, which is an apartment complex approximately 600 feet from the eastern edge, the western edge. However,
You need to get sworn in first, I'm sorry.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And state your name for the record, please.
James Schneller.
Thank you.
And during much of the deliberation.
Again, your address, please, now that you're under oath.
Yes. My address is 430 East Lancaster Avenue, Wayne. And my former address is 500 East Lancaster Avenue, which did receive notices here. And at which point I lived during much of the deliberations on the Board of Commissioners amendment of the covenant. I participated at length during the changes to the covenant that enabled this particular use.
But you don't live there now?
No.
Okay.
I'd request also taxpayer standing because I don't believe anyone else from the community has stood up for what I'm about to say. and it is in the public interest.
There is no taxpayer standing in in municipality's planning code jurisdiction. But maybe the law should be different, but the law is quite clear. There is no just general taxpayer standing.
I'd request private attorney general standing also.
Nor is there private attorney general.
I'm going to say you have 2 minutes. If you can get everything you have to say in 2 minutes, you're on. Okay? How's that sound?
I believe that's deprival of due process, sir.
You really have no standing here. Technically, this board doesn't need to let you have anything to say, but we're going to let you have your say. It's just you can't ramble on and keep saying the same things over and over again.
But yes, I have a concise list here. I'd like to, as you've heard before, I'd like to quickly object to the fact that there was some back and forth or hashing out of details before everyone gave testimony. That's why I respectfully interrupted. All the other businesses, and pardon me if I do sound like I'm rambling, but I like to, if I pick up the pace, it's not going to be as interesting. All the other businesses have signs, one sign facing north. Now, this is a planned business, and planned business, according to Section 280-58, is a modern, well-planned, integrated shopping and business district. This district happens to be Radnor's only integrated and well-planned district under PB that is integrating shopping and business. It was done with much buffering, traffic calming, and tree-lined avenue accentuation, and it is a pride and joy of Radnor. I have to object that there really has been no land development process, so the public has not been informed of the fact this should be getting the accentuation intended where such an integrated plan is being changed.
Mr. Schneller, you know this is not the planning board, right?
No, but I wish to
Okay,
that would support
but we can't deal with that issue.
But that does support my standing a bit, and it supports what I'm about to say about hardship, because there has been absolutely no showing of hardship, and I'm prepared to cite about 20 different cases where hardship, especially in a case like this, needs a little bit of punch, and there's absolutely no hardship been claimed. Moving on, I also have to point out that I believe under our code, with the signage they have on the monument signs, that square footage should be deducted from any signage square footage they're being given.
What you believe isn't what the ordinance calls for, so that's irrelevant. Moving on.
It's an undetermined.
It's irrelevant. They're allowed 60 square feet on a sign. Regardless of what you think, that's not what the ordinance says.
I'd ask the board to look into how
you need to talk to the commissioners about that. We don't have.
No, how the signage was determined when this covenant and when this place was planned.
I'm not
We have
going to
no
argue with you.
jurisdiction
Please
to
move on.
entertain that.
You do under 280-58, pardon me. As I mentioned, there's also meant to be a buffering and screening. I'm quoting from 280-58, Section 2. Building placement and building coverage
That's not what we're discussing tonight.
are included in your
Mr. Snelling,
consideration.
we're not discussing
Jim, we're talking about the signs.
I'm not here to argue a fine point. Let me say what I have to say.
No,
It doesn't pertain to what we're discussing.
This is
Believe
just
me,
about
Stay on
signs, Jim.
subject.
But this is legal
No,
argument.
you need to stay on subject. In front of us is whether we want to grant them 2 or 3 signs.
I just
That's it.
introduced
It's
with
the
a
building
short-
plan, the placement of the building is not what's in discussion here.
I understand, but if you pick me apart with legal arguments, I'll never get to the fact. I said buffering screening. My testimony is that the aesthetic and the public welfare considerations with these signs are going to be broken apart to what has existed on this avenue and this block for 40 years. This is not in the public interest. The signage should conform to every other business in the development under 280-58. I'd like to ask for resubmission of this signage to community development under that section and in conjunction with the other changes that they're apparently making.
It's not what's in discussion here. You
But
need to stay on subject.
I understand, but I want to ask conditions to that effect.
I'm sorry, you need to stay on subject. Why why they're not allowed to have 3 signs. That's it. You don't get a chance to talk about the whole ordinance, or we'll be here till Tuesday.
I understand, but my fact is related to what I'm saying as argument.
You got one more. Please make it a good one.
While they may claim this is not contrary to the public interest, I claim it is contrary to the public interest for the reason I just said. I believe that there is a strong public policy in the Radnor ordinance that you ought to conform to as far as signage. There has been no hardship shown, so why should this particular 2 blocks suddenly be blemished, to be kind, with 3 signs?
Okay? Thank you very much.
I'd also ask that
Mr. Snelling, you're done, please.
there be
Thank you.
a heeding of the covenant. It has been amended into the zoning map where the R1 characteristic of the avenues be included in your consideration.
It's not in our field.
If
Please.
it's in the map,
Thank you.
I
Thank you.
ask you take a look at the map right now.
Okay,
Thank you.
thank you. Any other comments from anyone in the audience?
By the way, Mr. Lewis, I misspoke. It's an instructional sign, really not a directional sign. Technically, on the ordinance, that other sign we talked about, it's an instructional sign. Yeah. I'd like to make a motion
Okay,
that, subject to the applicant agreeing and to replace the south-facing sign with an instructional sign that fully conforms with the provisions of our ordinance, that we grant the variance to allow the 2 signs requested for the north and west faces of the building as shown in the plans.
not to exceed 46.3
As shown in the
sign.
plans, as shown in the plans.
As shown as a modified plan, because they're going to have to take the one facing off.
Right, but we're only approving the north-facing and west-facing signs, not the south-facing. There won't be, and has not been asked for, an east-facing. And they may, as long as they conform, have an instructional sign on the ground to replace that.
Do we need to get into that? I mean, if they can conform to the code,
That's
they
right,
can
right.
do what they
Right.
would, they please.
Okay.
And do we need to say anything about illumination?
I think
No,
we need
that's not
to.
before
No,
us.
it's not before us.
Well, no, it
They-
was.
they don't have approval to-
There's a reference in one plan to illuminated letters. And now, remember, all of our orders specifically cite the zoning code provision, which would not, in this case, pick that up. But, so that would cover us as well. But
We'll just
it'll be clear.
emphatically state that we are not granting a variance to have an internally illuminated sign on the property.
Or we can say to be illuminated in accordance with the code?
I think there are various ways to do it, and I'll send an opinion. But I think since it came up, we ought to address it in the opinion.
Okay.
Or the
And we
order.
would certainly be amenable to.
Okay. Kevin, you have something? And does the township have anything? You're here for this.
Yes, we actually, this issue has come up on numerous applications, and there is a provision that says signs shall not be internally illuminated unless in accordance with this ordinance. Section 125D.
It says except where permitted by the ordinance.
Okay.
There has to be something specifically permitted in the ordinance to be allowed.
We have discussed this with staff and with the township solicitor. Section 125D permits internally illuminated signs, and provided they meet the provisions of 125D, they can have an internally illuminated sign. That is the township's position, and that has been my interpretation of the code for internally illuminated signs.
Yeah, but I don't think wall signs can be illuminated. Doesn't it say that?
It's really not the point. They haven't asked for relief. We
Right.
haven't granted it. If he says they don't need it,
Okay.
I guess we'll never see it. They'll deal with it.
Yeah, well, it's, yeah, if the township takes a position that this is okay and issues the permit, we have no
Okay.
enforcement powers, and it
Okay.
doesn't come back unless somebody.
Okay.
But
Jim?
we're not going to grant an affirmative authorization.
And we are not requesting any deviations from the township's
Okay.
illumination
Okay.
standards.
I would agree with the proposed motion as noted by Mr. Cutler.
I do agree with that.
Also?
2 signs.
Okay. Thank you.
Thank you very much for your time this evening.
Yeah, I am. Yeah. No, I'm going to sit right here.
Is John, Goshen Road is continued till next month?
June.
Yes, it is.
Third Thursday.
I just remember.
Huh? Okay. We're going to take a 5-minute recess. It looks like it. Norma, you ready? John? Yep. Appeal 2883, applicant CF Holloway III and Company, Inc., property located at 229 West Wayne Avenue, Zone C1 and R5. The applicant seeks to appeal the Township Zoning Officer's grading permit determination and received an application on May 22nd, 2012 regarding impervious surface calculations. I am recusing myself, and Mr. Dolan will be chair on this.
Mr. Chairman, there was a slight typographic error in that where it's the grading permit. It was a zoning determination under 2883.
It's a zoning determination. Okay, 2883 applicant CF Holloway III and Company, Inc., property located at 229 West Wayne Avenue in Zone C1 and R5. The applicant seeks to appeal the Township Zoning Officer's zoning determination received by the applicant on May 22, 2012 regarding impervious surface calculations. Mr. Falcone.
Do you want to speak first?
I'd like to enter my appearance on behalf of the property owners. I'm Harry Speece, Davis Bennett Speece and Living Good, located at 130 West Lancaster Avenue, Wayne, and I'm representing Lawrence T. Adelberger Jr. and his wife Joyce Adelberger, who are the owners of the property in question.
Thank you, Mr. Speece.
Mr. Chairman, also, I am Peter Nelson. I'm here on behalf of the Township. My office acts as a Township solicitor, and we will be defending the zoning officer's opinion that's being appealed, as well as opposing the alternative relief for variance. Thank you.
Thank you, Mr. Nelson. Mr. Falcone.
Thank you. My name is Dave Falcone. I'm with Saul Ewing here on behalf of Kaz Holloway. We believe this appeal essentially comes down to an interpretation issue that we've asked the zoning officer to make. He's issued a written determination, which we don't believe is consistent with the language of the ordinance, which we believe is in fact clear in our favor. To that point, it should be noted that this has been discussed in front of the Planning Commission on 2 occasions, and on both occasions it's been opined from Township staff that they believe the language is unclear. Again, we don't believe that to be the case, but certainly are willing to engage in the discussion and look at the language. Looking to the zoning ordinance, which is what we're underneath, would be the... Yes, sir.
I'm not finding my copy of the letter, the determination letter.
Okay.
My packet, is it your packet? We don't seem to have a copy of that. Sorry, I'm supposed to put my mic on.
Okay.
I do not have a copy of the determination being appealed in my packet, and
There's a copy here in the file.
do we have copies that can be?
I don't have one either.
I do not. Perhaps the Township does.
I have copies for everyone if you wish for me
Yes,
to
I'd
distribute
like to
them at
read it.
this time.
Yes, please.
Should we take a 2-minute break while you all read the letter?
Yes, thank you.
Yeah, I just wanted to, there's nothing in the agreement of sale that gives the authority here of the owner to make this application. So will you make sure that we put them on and just have them agree that this is being made with their authority, just
Yes.
to cover that?
I actually only have 3 copies, but Kevin's going to make one.
Okay.
Oh, okay.
But Kevin's coming back.
Yeah.
And what I've handed to you, and David, so you know, is a copy of Mr. Pachansky's letter, and then the letter from Mr. Falcone that Mr. Pachansky is responding to. So you have both the request and the answer.
needs one. I got one.
You know, I suppose we should also put into the record the memorandum from the Planning Commission.
I didn't get one of those.
It was circulated via email.
Oh.
I will read it into
I don't have
the
a
record.
copy of that.
I was prepared to, as part of my case, to bring that into the record if you wish. I have copies of that
Well,
for
since
everyone.
submission to the Planning Commission is required by the ordinance, and we have it, we may as well just take notice of it and put it in the record as it
Okay.
is. I don't think anybody
David,
has to
I have a
use
copy
it.
for you.
Okay, great.
And I'll read it into the record for the folks watching at home.
Anyone else need a copy?
If I can have
This is a memorandum dated June 11, 2012, to the Zoning Board from the Radnor Township Planning Commission regarding Appeal 2883 of C.F. Holloway III and Co., Inc. The applicant is appealing the Township Zoning Officer's zoning determination. At their meeting on June 4, 2012, the Planning Commission of Radnor Township reviewed the above-captioned application in accordance with Section 28142B of the Township Zoning Code. This application involves a land development, and the Planning Commission has reviewed the plans for this land development at several public meetings. On June 4th, after discussing this application to the Zoning Hearing Board, the Planning Commission adopted a motion supporting the Township Zoning Officer's interpretation of the zoning code being challenged in this application. Specifically, the Planning Commission agreed that the area of a lot located within the right-of-way cannot be included in the calculation of the impervious surface ratio for that lot, and fully supported the zoning officer's calculation of the impervious surface ratio for the lot involved in this zoning hearing board application. Lastly, this motion also included the Planning Commission's opposition to the granting of relief in the form of a variance to the applicant concerning the amount of impervious surface allowed on the subject lot for this land development, should the zoning hearing board agree with the Township Zoning Officer's interpretation of the calculation of the impervious surface ratio. Thank you.
To explain for those in the audience here or at home, under our code, where a zoning application, an appeal, specifically involves a subdivision or land development, it is mandatory that a copy of the appeal go to the Planning Commission. The Planning Commission has the power to review everything related to it, and then they may or may not, but they have the right to make comments to the Zoning Hearing Board. So that was given to us in response to that submission, which was required by our ordinance. So this is not just a gratuitous comment by the Planning Commission. That being said, take it away.
Floor is yours, Mr. Falcone.
Actually, since we've just had these entered, do we want to get exhibits sorted out before we proceed? I would respectfully suggest, because it doesn't really matter, that the letter to Mr. Falcone from Kevin Konchansky with dated May 22nd, which attaches Mr. Falcone's letter of May 21, be put in collectively as Exhibit T1. I would submit that the memorandum from the Radnor Township Planning Commission dated June 11, 2012 be T2. Okay. In terms of the materials that we have in the application, I would submit that the application, which includes a summary of the argument to be made by the applicant, be labeled A1. We have various plans that appear to be a stapled set, and I think each one of these ought to be labeled separately. That's my suggestion. I would make the front one A2, the second one A3, the third A4, the fourth A5, the fifth A6. In the application packet, there was a Google, I guess this is Google Maps, it looks like an aerial photograph actually with various annotations. It's a one-page thing. I would suggest we make that A7. And the redacted agreement of sale with the Adelbergers, I would suggest that be A8. And those are all the exhibits that I've received so far.
Mr. Falcone, do you have any other exhibits you'd like to?
No, we do not.
Okay. All right. Any other administrative business?
No, I have trouble with all these papers.
No, I agree. All right.
I don't want. I want to be on the same page as everybody.
Now the floor is yours.
Sounds good. So again, we believe we're dealing with an interpretation issue, primarily with the interpretation of how to calculate impervious surface in the C1 district in Radnor Township. Looking specifically to the zoning ordinance, we find some guidance, though generally a definition of lot, which is what we believe much of this discussion hinges on, which does not address the specific issue which is in front of the board this evening. Namely, what constitutes a lot? And does the area within the right-of-way constitute a lot? For as far back as anybody can remember in Radnor Township, it always has. That's been with every application Mr. Holloway's made, and I have this evening with me Dave Fiorillo from Mominy, who's been practicing in the township for over 20 years. And that goes back through solicitors and through engineers and through zoning officers, but for Dave's career, which is over 20 years. It's always been defined that way in Radnor Township, and that's because Radnor, unlike many other townships, deeds properties to the center line of the road, whereas many other townships will take the dedication of the road and your deed will go to the right-of-way line. That's not the case in Radnor. In essence, Radnor, you get the entire lot to the center line, and the right-of-way itself is essentially an easement. So case law in Pennsylvania is clear that easements are not netted out of your overall lot area in calculations. In fact, a case which Mr. Ryan is probably familiar with, which is Locke, discusses easements for vehicular travel. They are not to be netted out when calculating a lot area. So we're looking at an interesting situation because of the way Radnor deeds lots. So with that in mind, we turn to the definition of lot in the ordinance. There is no guidance in that language as to whether or not you include or do not include the area inside the right-of-way. So we continue then on exactly what we were looking for, which is the calculation of impervious surface. When you look to that definition, I believe you do find guidance. And I believe you find guidance in the manner of an amendment which was made in 2000. The language states, in total, impervious surfaces are surfaces that do not absorb rainwater. All buildings, parking areas, driveways, interior roads, sidewalks, and areas of concrete and non-porous asphalt or other areas of a lot as determined by the township engineer. And then specifically, this definition shall not include any portion of a lot within the street, located within the street. So to include language which says impervious surface does not include area located within the street, area of a lot, it without question stands to reason that they've included language to carve out that area. If, in fact, lot did not include any area within the street, which is what the township is suggesting, that language is superfluous and unnecessary.
Let me ask you,
Yes,
why
sir.
wouldn't it be, if you're taking out the whole street, which is defined as to include the right-of-way, might this not make sense in terms of we're just taking the whole street out? The whole street goes. You're not going to be penalized for the portion of your lot that's under the cartway, but you're also not going to get the benefit of the portion of your lot that is presently pervious but is within the street right-of-way. Because it seems to me you have to do one or the other. If you do include the street right-of-way that's under the lot, why wouldn't you add the impervious back in, absent something else in the code that would require that result? Because it seems to me the definition of lot can be defined by the ordinance. I mean, lots are often, our code, I believe, has a I believe steep slopes are there's a penalty for steep slopes, there's a penalty for flag lots. So you can have, by ordinance, vary a number of things. I do note, and correct me if I'm wrong, that the definition of a front yard goes only to the street line. Now, what is a street line? And it says a street includes the right-of-way. So while I would like the word street line to be being the edge of the right-of-way, I think a street, it's hard for me with the definition of street and then street line to say that the street line is actually the cartway as opposed to the ultimate right-of-way. But front yards are calculated, and certainly been as long as I've been here, calculated to the ultimate right-of-way, not to the cartway.
But a yard, Mr. Ryan, I think we can all agree, simply creates a building lot. So a building envelope. What we can't do is then take a definition of yard, which really has no basis on creating the lot. It's simply defining an envelope. I think that's a separate definition, which doesn't really impact the definition of lot. I think you need to focus on the definition of lot. And the definition of lot is absent any language or any guidance as to whether Radnor, when interpreting a lot, includes the right-of-way or does not. You must look to the entire ordinance. And when you do that, I think the definition of impervious surface, which is the definition that we are here for tonight, clearly shows an intent by the township to carve out any portion of a lot located within the street. So when you read the language as it's written, which we must when interpreting an ordinance, why would it be necessary to say any portion of a lot located within the street if there was no portion of a lot that's ever located within the street? How
Can I make a point of order here? Is there going to be any testimony, or are we just going to be dealing with a legal argument on both sides?
Again, I have Mr. Fiorello here to offer testimony based on his experience in Radnor Township for the past 20 years, as well as...
Yeah, okay. I mean, I don't know if that bears on. It's really a matter of our interpretation of the ordinance.
I agree, Mr. Culler.
So there isn't going to be any factual testimony, other than putting on the owners just to...
That's correct.
Can we just get that out of the way? Let them put and then let's hear both sides of the argument before we intervene, because the township's going to want to speak too, and I don't know if anyone else does, as to everybody's view of this ordinance.
And I'd appreciate having, let's put the facts on first, and then we can do legal
Yeah, I mean,
argument
apparently there
after.
aren't any facts except the fact that the owner is going to say that he permits this application on behalf of his buyer, and there aren't any of the facts.
There is an alternative request for a variance, and I assume they're going to be putting on evidence in order for that to obtain that variance.
That's only to the extent we aren't successful on our interpretation argument.
Okay, well, let's.
Well, maybe we should bifurcate it. Let's deal with the interpretation argument first.
Yeah, but in any event, shouldn't we clean up the owner issue?
Yeah, let's clean that up, and then we know that we're properly joined and everyone has standing. And
Mr. Spees.
As I indicated, I represent Mr. and Mrs. Lawrence T. Adelberger, Jr. Mr. Adelberger, have you entered into an agreement of sale?
he needs to be
Let's get him
sworn.
sworn.
Harry, got to get him on the record.
Sir, if you'll raise your right hand, you do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the
You'd
truth.
have to decide.
I do.
And state your full name for the record, please.
Lawrence T. Adelberger, Jr.
Thank you. And spell Adelberger.
Part,
Spell your name.
oh, Adelberger.
You entered into an agreement of sale with C.F. Holloway Company earlier this year to sell 229 and 255 West Wayne Avenue.
Yes, I have.
And are you authorizing the Holloway Company to be present tonight with this zoning application?
Yes, I am.
Anybody have any questions for Mr. Adelberger? Thank you, Mr. Adelberger. Okay,
I can continue.
please.
So, continuing through the ordinance, the only definition of lot area, and we believe it to be relevant only because of the time in which it was amended, when you look to the saldo, which is guidance with respect to township intent.
I think you should say subdivision and land development ordinance.
To the
Not everybody
subdivision and
knows
land
the buzzword.
development ordinance. I apologize. And when we look to the definition of lot area in the subdivision and land development ordinance, we see an amended definition which was amended at the same time the definition of impervious surface was amended. And we believe this is incredibly relevant because the language states a lot area is the area contained within the property lines of a lot shown on a subdivision plan or required by this chapter, less the following. And then skipping to 4, the land area within an existing public right-of-way located within any R1, R1A, R2, R3, R4, R5, and R6 residential zoning district. Again, by statutory construction, the ordinance was drafted to exclude certain zoning districts. It includes the residential, which in our plan, you will see it was netted out in our calculations in the R5 portion of our application. This deals specifically with a C1 area, which this subdivision and land development ordinance, when defining lot area, does not say you net out the right-of-way. By omitting that language, case law suggests that you cannot then implicate simply by having some that it includes all. In fact, it suggests exactly the opposite. By listing some and not others, you've made a clear intent to specifically define just that area. So where the C1 district is absent in this definition, it shows an intent on the part of the township to not include or to allow the inclusion of the right-of-way area when determining lot area in the subdivision and land development ordinance. I know we'll hear discussion tonight that this is not a subdivision land development issue, and I agree with that. However, there is no guidance in our zoning ordinance, and there is an amendment made at the same time pertaining to a similar subject by this township. And at that time, they elected to include language which states, this definition shall not include any portion of a lot located within the street. And then comparable language was added to the subdivision and land development ordinance, which speaks to what is included within the right-of-way of a street when determining impervious and lot area.
I would have to object. I mean, if there's an ordinance out there that Mr. Falcone wishes to refer to, I think it needs to be entered into the record and shown how, how does this, both of these particular languages were adopted at the same time or at similar times, or how they're related. I mean, the document itself speaks for itself. It should be made part of the record if he wishes to rely upon it.
I'm simply relying on the ordinance number, the amendment number in the existing ordinance, and the date of that. We believe the language stands for itself, whether it was amended or not. But the language is certainly clear that in subdivision and land development, when you contemplate what a lot area is, and mind you, lot area is not a defined term at all in the zoning ordinance. But when you define that term in subdivision and land development, you carve out the right-of-way in the residential districts, and you do not in the commercial districts. And that's what we're here for, to determine whether or not you include that in a C1 district.
I think it would be useful, I mean, I think we can take judicial notice of the township's ordinances, can't we? I mean, they are what they are, and they can be cited.
You certainly could take, yes. I'm certainly not going to object to the admission of them into the record. However, I think if he's going to make an argument based on, the closeness or the similarity of these two ordinance provisions, he should have a copy of that actually ordinance to enter into the record, because it is a document. He's basing his argument upon the document's language. Let's get the document into the record.
Well, really, what I'm basing my argument on is the exact language of the ordinance as it reads now, as amended in 2000.
Okay, why don't we cut through, may I suggest we cut through this? The two printed volumes of the ordinance, which have the language that I've heard being read into the record and referred to, is there any question that these are authentic?
I don't believe so. Certainly, I've not been going along as he's read them. Sorry. But I do believe what he has read is the correct verbiage that is currently in effect.
Well, I would suggest that I'm looking at the printed volumes of July 2009, and for the subdivision and land development ordinance, March 2008. I think those are the most recent printed items. And
Actually, I believe there's a printed version of April 2011 for the zoning ordinance.
okay.
How
How come I didn't get that?
I pulled it off the township's website.
But
So
it's
that's
printed? Okay.
Yeah, that's what I have right here.
Ah, all right. So that's-
I think we'd all like to have that.
yeah, I think so.
Otherwise, we're going to resign en masse.
I will look into that for you.
Do you have copies of that one?
The existing ordinance is the one you're looking at, which is the one I have, which is from the township website, the same as your solicitor. And that's the language included in the present
This is
ordinance,
not
what
right
I've
here.
read.
I got
And if
that.
you note the language in that ordinance, it shows when there's been amendments to the ordinance.
Let me ask you this.
Yes, sir.
Is there any dispute that the ordinance as on the website today, June 19th, 2012, is indeed the correct ordinance? Because should we just incorporate the website?
We don't object to that.
I wouldn't object to that, but at the same time, I have absolutely no firsthand knowledge that that is the case. I have no idea how often the township updates
Well,
the ordinance on the web.
Would you want to read the definition of impervious surface into the record? And
Yeah, let's do that.
I think your ordinance is.
Is this from the zoning code?
Zoning code.
Well, we all have that in front of us. That hasn't changed.
Well,
Yeah,
there is no, I mean.
I think the
nobody's-
debate over is whether the saldo provisions are accurate, but if you consider them relevant. But the zoning language hasn't changed. The only relevance here is the definition of street, definition of impervious surface, definition of lot.
Yes, sir.
And whatever the law is that bears on these things and our interpretation of the language in light of that. I mean, I don't know why we need that. We all have it. It's a judicial notice. We take judicial notice of it. Here it is. We all have it. It hasn't changed.
If there's no dispute about the definition of lot from the subdivision ordinance that was read into the record by Mr. Falcone, including the date of the amendment for that, then why don't we take judicial notice
The definition of lot or lot area?
Lot area.
Lot area. It's a different,
What-
very different thing.
Mr. Falcone, can I ask, what is the, at the end of the definition of lot area, what ordinance was that definition added? Does your?
So there's actually two. If
Okay.
you look at the top, lot area, it says amended 7-17-2000 by ordinance number 2000-20.
Yes.
And then at the bottom, added 5/22/2006 by ordinance number 2006-15. So we have the same language.
Yeah, that matches,
Yeah,
yes.
so we have the same, we're looking at the same language in the subdivision and land development ordinance.
Okay.
Okay, so we have judicial notice of the zoning ordinance, and we agree that unless somebody else wants to mention the subdivision ordinance, the only provision that we're taking judicial notice of is the definition of lot area set forth at subdivision and land development ordinance, section 255-6, definition of lot area.
That's correct. And then, so if we continue through the zoning ordinance, if you go to 280-48, which are the area and height regulations for the C1 district, the A is actually stated lot area and width. So we believe the concept of lot area is very relevant in determining exactly what criteria apply to our lot. It's crucial, essentially, because when determining our lot and determining, again, in Radnor, our title line goes to the center line of the street. That's what our deeded property is. So to suggest our lot area for calculation of all of these things, not just impervious, but building size, lot size, everything, to suggest our lot is now shrunk by the area located within the right-of-way, and although I know Mr. Cutler said it's not terribly relevant what the township has done in the past, but it would then take every lot which has been created and granted permit by the township in the commercial district and make them non-conforming. Every lot. Because for 20 years, permits have been issued based on one interpretation of the size of a lot. And this is the first application where this has become an issue under the new interpretation.
excuse me, now you're alleging a fact now. Do you have any proof of that
Well,
fact?
Mr. Kachansky stated as much in front of the Planning Commission, so I'm sure he'd state again this evening.
I mean, that's a matter of fact, and if you want to put testimony on as to that or tender proof to the board, otherwise we can't recognize
I'll
it.
happily question Mr. Kachansky to that. Mr. Kachansky,
I think he needs to be sworn first.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
And state your name for the record, please.
Kevin Kachansky?
Mr. Kachansky, was this issue with respect to calculation of lot size discussed in front of the Planning Commission
Yes, it was.
while you were in attendance?
Yes.
And were you at that time asked whether or not this was a new township interpretation and whether or not this was, in fact, the first time in which it became, quote, an issue?
This issue did come up. I do not believe that I indicated it was the first time this issue came up. Every application since I've been employed by Radnor Township, this interpretation has come up, and it came up the very first time this application was submitted in January.
Well, that's not the case, is it, Mr. Kachansky? Because the first review letter issued by your township engineer did not raise this issue. So it wasn't raised initially with this application.
I can't account for what the township zoning or the township engineer wrote in his letter, but I can tell you my interpretation has been consistent on every project.
Have you been asked to make an interpretation on this by any other applicant?
Not on this project, no.
Okay. So this is the first time you've been asked to make an interpretation of this provision with respect to an application.
On this application, yes. On other applications, no.
You've made written determinations on this provision.
I have not been asked to make written determinations. They've been verbal.
Okay. So prior to you, and you may not be able to offer testimony to this end, but perhaps your solicitor or, again, Mr. Fiorella, but prior to your entering the role of zoning officer, was this the township's interpretation of this provision?
I do not know.
Objection. It's not relevant. I mean,
but it is relevant.
There's no reliance by this applicant by a previous determination by the township.
That's not
whether
accurate.
Whether or not
accurate.
Wait,
not in this,
let him
yeah.
finish his argument.
In this particular project, there's been no reliance. The township has consistently stated that this is our interpretation of how the impervious coverage needs to be calculated for this particular project within this particular zoning district. And the fact whether or not the township has interpreted it differently for the last 20 years is irrelevant because there's no reliance, and just because the township has made a mistake for 20 years doesn't mean now we have to continue making it for the next 20 years. And certainly I can't testify as to whether or not this is the way the township has interpreted it in the past. Mr. Kachansky can answer that, but I can tell you he's going to say he doesn't know either. We're both relatively new to this township and to our respective positions, but I think it's completely irrelevant whether or not that's the case. And I object to this line of testimony.
We don't believe it's irrelevant.
One second. Are you going to offer any evidence on reliance?
I am. I'm going to have Mr. Holloway testify that when he purchased this property, he and Mr. Fiorella prepared a plan based on 20 years of experience in the township and how this calculation was made. And based on that 20 years of history, he believed this to be a viable site. It should be noted that if this interpretation, again, is made where you cannot include this portion of the lot, it makes most development on this property very, very difficult. Because, again, you're taking a lot which has been created by this township under one provision and now suggesting that it's completely different and carving out a very large portion. And it's extremely relevant for this lot because it's a corner lot and has two frontages. So you're now taking out around the corner in the right-of-way. So a corner lot is overly burdened by this interpretation.
Well, again, we may be able to save a lot of time here because if this board agrees that the determination by the township officer was wrong, then we don't have to worry about prior decisions, reliance, or any facts that might otherwise come in if you're talking about a variance. I think let's try to keep it narrow first on this issue of our interpretation of this language and whether we agree or do not agree with the township officer's determination. And for that, I mean, if you have anything further to add, that's fine. Then we should hear from the township and anyone else, and then I think we ought to consider that issue. We may get no further than that. Let's decide it on its narrowest grounds if we can. And if we can't, then we'll deal with the other things.
I have then just one more point, and it's a point I'm sure this board has heard many times, but one I think is important to create this record. When we're looking to interpret the language of an ordinance, it, by law, must be interpreted, okay, the most permissive and widest use of the land. Most permissive and widest use. That's very, very important when interpreting language in an ordinance. And we believe that when you interpret this language in the ordinance in its most permissive manner, it permits what we are proposing.
I think what you're saying is that to the extent that there is an ambiguity, the landowner gets the benefit of the ambiguity.
Well, certainly that as well. But I also believe that even when there is not ambiguity and there is clear language, it is to be interpreted in its most permissive and widest use in favor of the applicant. Certainly, if there's an ambiguity, that should also be ruled in favor of the applicant, because case law suggests, as well as the MPC, that the ordinance is there to encourage use of land, not to restrict it.
It is true that for genuine ambiguity, the landowner gets the benefit of the doubt. There are cases that very expressly state that it has to be a real, genuine ambiguity, not just creative creaking of words to create one where it doesn't exist. The ordinance has to be clear enough as to what is required.
We're here, so we think it's clear one way, and the township thinks it's clear in another.
Yeah.
I'd say
The township is about to tell us what they think.
Yeah.
Well, actually, Mr. Spees, did you want to add argument?
Well, if we're only on this narrowest of issues,
And we
we're
are.
only on the
And we are.
narrowest of issues, how you interpret or whether you feel there has been a misinterpretation of the ordinance. I don't have too much to add. I do want to talk and give some argument and discussion about a little bit about the history of the property and the prior attempts to develop this.
I don't think that's relevant, Harry.
Not to this.
Not to
It
this
may be
issue.
relevant to the variance.
Let's save the time. If it becomes relevant, if we go further, you're certainly
Right.
entitled to come forward with your.
And reliance is
Yeah.
another area I wanted to get into just briefly with the Adelbergers, but I understand we're just talking about the narrow issue.
I mean, there is a chance
The
that after the
interpretation.
board has heard all the arguments, that we're going to decide that the interpretation was wrong, and in which case you never
Yes.
have to reach any of that. And if we don't,
Okay.
we'll deal with the rest of it.
All
Let's-
right.
Okay.
let's take, everybody preserves all their arguments and the ability to put on witnesses as necessary.
Mr. Nelson.
Thank you. I get a good evening. Just to address Mr. Falcone's statements. I think it's a much simpler, straightforward issue than is being presented by the applicant. The question before you is how the impervious surface coverage is calculated within the C1 district. Now, they've tried to expand it that we are interpreting how every lot size or lot ownership is being decided. That is absolutely wrong. The only issue the township interpreted here and decided here and issued an opinion letter here is on how do you determine how to measure impervious surface coverage within the C1 district. And what we said was, since impervious surface, the definition of impervious surface in the zoning ordinance specifically excludes the street right-of-way from that definition, we said clearly, as Mr. Ryan talked about early on, that certainly makes sense that you also have to exclude that from the base lot area in determining what the percentage of the lot is being covered. Now, we are not redefining what is considered a lot in the township. We are not redefining what is owned by individual lot owners. We are merely stating that if the impervious surface located within a street right-of-way is not going to be included in that calculation, then the underlying land in the street right-of-way is not going to be included in that calculation either. It's apples to apples, oranges to oranges. What the applicant is trying to do is trying to pull a definition from the saldo that supports their position but it's completely unrelated to what is being discussed here. First off, if you look at both the Saldo and the zoning ordinance definition sections, both of those sections start off with language that state something to the effect, as used in this chapter. The definitions, each ordinance specifically says that the definitions listed below are applicable only as they are used in that particular chapter. There's nothing in the Saldo and nothing in the zoning ordinance that says that when something is not defined in this ordinance, look to the other for the definition. Furthermore, looking to the Saldo definition for a description of lot area is completely wrong in this situation. If you look at a definition in Saldo regarding impervious surface, that definition includes the impervious surfaces located within the road right-of-way. If you look at the definition of impervious surface ratio in the Saldo, that includes the impervious surface in the road right-of-way. So in the Saldo has taken an expansive view of impervious surface and how to calculate it and how to calculate its impact upon a lot. Zoning has taken a much less expansive view. To pull a single definition out of the Saldo and say, well, this is how lot area is defined, should be defined in the zoning ordinance, is completely wrong. Saldo approaches the subject from a different direction. It shouldn't be done. It shouldn't be done legally because there's no basis to do so. And it shouldn't be done on a philosophical level because clearly the Saldo is dealing with impervious surface differently. And then lastly, if you look at what is the purpose of each ordinance, in the zoning ordinance, impervious surface, there's a definition of how much is allowed. How much impervious surface is allowed on a lot in the C1 district. In the Saldo, the only area that impervious surface is discussed is that it requires on subdivision and land development plans that those plans indicate the amount of impervious surface upon the lot and then indicate the amount of what's the impervious surface ratio. It's just a matter of what needs to be written on the plans. There's no maximums, minimums, how it affects the actual plan. It's just a listing of information. And in fact, if you look at the plans that were presented to you, and if I believe if the applicant's engineer was testified to, he would testify that they actually don't meet that Saldo regulation because they don't put on their plans the impervious surface or the impervious surface ratio as it is defined in the Saldo. What they do is they put together this amalgam, which is they take the impervious surface definition from the zoning, they take their lot definition from the Saldo, and they calculate it and they
Excuse
put
me,
that
sir,
on
is that having to do with the narrow issue we're talking about now?
Well, what it has to do with is that they are making an argument that clearly benefits them, but is not logical. If you look at zoning, the definition of a lot specifically says that a lot is an area where a principal building or buildings can be constructed and the related open spaces. It has said a lot does not include that definite lot does not include street, the street right-of-way. Clearly, a street right-of-way is not an open space. And
We'll make that determination.
And you can raise it on.
Yeah, we got your point. We're going to get his. We'll
Mm-hmm.
decide what we think about it. And we'll have a nice discussion in front of you all.
And
telling
you'll have
you
time
how
to.
we think.
We'll give you time for rebuttal.
The lot, that's the way a lot defined. It's an area where a building can be built and the open space is related to that building. A street certainly is not considered an open space. A street certainly is not a location where a building can be built. So if you want to look specifically at the language of the zoning ordinance, the language of the zoning ordinance clearly supports the township's interpretation on this issue. Another point, I'm sorry, didn't mean to tease you like that, has to do with this issue of ambiguity. The section Mr. Falcone referred to in the MPC is section 603.1. That section states, in interpreting the language of zoning ordinances to determine the extent of the restriction upon the use of the property, the language shall be interpreted where doubt exists as to the intended meaning of the language written and enacted by the governing body in favor of the property owner and against any implied extension of the restriction.
And that relates to use only?
Pardon?
Does that language relate to use?
It relates to the use of the property, yes, that's what it says.
But is there language in there that relates to dimensional issues?
No.
Okay.
And the point here is there is no doubt. I mean, the applicant actually said there's no doubt on how this is interpreted. They think they're for sure that they're correct. Well, guess what? The township feels for sure we are correct also. There is no ambiguity here. The ambiguity they're trying to create is by saying, oh, well, lot area is not defined, so that makes the ordinance ambiguous. That's simply wrong. I mean, there's dozens, if not hundreds of terms in the zoning ordinance that are undefined. Just because we have an issue here that's revolving around an undefined term does not make the ordinance ambiguous and does not create a situation where this section 603.1 should be followed. Furthermore, the general rule of thumb is when there is an undefined term in a zoning ordinance, what you look to is the common usage of that term. You don't go looking to how it's defined in other township ordinances. You look to how it is commonly used. And a person who owns a lot, most of us are going to say, it goes to the street. That's where my lot ends. We don't think, oh, I actually own to the center line. And I bet majority of people here in Radnor don't realize if their deed does go to the center line that they own to the center line. Most people think that their lot encompasses from the street in along the property boundaries. That's the common usage of a lot.
Yeah, but it's also common in the township to have developments with dedicated streets. I mean, it seems to me, well, no, I think it's relevant because it makes sort of a hidden windfall or penalty as to whether your lot goes underneath or whether the township owns the entire
Actually, it's a matter of
street.
property law. It has nothing to do with zoning, what you own. That's, I mean, there'll be a discussion we can have when they're done making their arguments. And I want to ask Mr. Kachansky something, too, about that. But do you have any more arguments to make, sir?
Just a few more.
Yeah.
I'll be done soon.
I
want to also focus on the C1 restriction that is the center of this. That restriction says, quote, not more than 60% of each lot may be occupied by impervious surfaces. There's no mention of lot area anywhere in that restriction. It's the applicant who's trying to bring it in to try to create an ambiguity, to try to create the situation where they can argue, oh, this is how we calculate it. And the reason why they argue it, as they said, the project they're proposing needs this interpretation or needs a variance. If they don't get the interpretation, don't get the variance, their project is dead as it's depicted right now. So the applicant in this situation, the applicant bears the burden of proving that the zoning officer is wrong. I don't believe the applicant has showed that. The applicant can't show to any specific language that actually supports their argument. They have to connect it to language in the saldo, extrapolate certain sections of the zoning ordinance. That is not enough to meet their burden that the zoning officer's interpretation is wrong. There's no zoning ordinance language that supports their argument. They have to rely on the saldo. And what you really should be looking to is the common usage here, if it's not defined. There's no ambiguity here. There's no reason why you need to look to Section 603.1 of the MPC. And lastly, when the rule of statutory construction applies to interpretation of zoning ordinances. And one of those rules is that any interpretation must be logical. It can't be absurd. Clearly, the logical interpretation here is if you're not counting impervious surface in the road right-of-way, you shouldn't be counting the land underneath that road in that calculation. I mean, you shouldn't be creating this fiction where the road is considered pervious. And if this is the case, if this is how the township has interpreted over the years, well, I think it gives probably a good explanation of why this township has a lot of flooding problems, because they've followed this fiction that roads absorb rainwater, and clearly they do not. It is absurd to accept their explanation of how this is calculated. The logical explanation is what the township is fighting for. Thank you.
Mr. Kachansky, I have a factual question to ask you. If someone came in to develop a house, and for instance, let's say R4, where the minimum lot area required is 7,000 square feet, would you exclude the area within the road right-of-way in determining whether they met that requirement or not?
We look the lot area, are they, to, I guess, answer your question, is it an existing lot of record, or are they creating a lot? Because if it's
It shouldn't make any difference, as a
if it's
matter
an
of law.
existing lot of record, we would measure to the right-of-way as is determined by the township and base the lot area off of that. If the lot area is less than the minimum required for the district, it would be considered a non-conforming lot and could be developed in accordance with the non-conforming provisions of our code.
So if a lot were 6,000, well, my example, if a lot were 6,000 feet outside the right-of-way and 7,500 including the right-of-way, you would say they're non-conforming.
Correct. It would be based off of the 6,000
And that
square
would be
feet.
based upon what in the code, would you say that?
When I look at the definition of impervious surfaces,
No, we're not talking about impervious surfaces. We're talking about lot area. Right now, I'm not talking about impervious surfaces. Please, the witness is testifying, please. What would be your authority in the code for making that determination?
we would measure, it's standard practice is to measure to the ultimate right-of-way.
A standard practice isn't authority. It's history. I'm serious about this. Is there authority in the code for that?
There's no provisions that I'm aware of that tell you to do one versus the other.
No, I don't
we go to the ultimate right-of-way as we do for any new land development that's coming in. All lots are based off of the right-of-way and not to a center line of a proposed road. So to be consistent with new development, old development, everything is measured to the right-of-way, as are setbacks and other dimensional requirements of the code. Everything is based off of the right-of-way.
Okay. Anybody else have an argument to make about this before we start discussing? You have a legal argument to make on this issue?
Okay.
Are they done with their presentation?
We're only talking about, we're on the narrow issue now of our interpretation of the language of the ordinance. So whether they're done or not depends on how we interpret that when this gets put to us for discussion decision.
Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And state your name for the record, please.
Baron Gemmer, Baron Gemmer. Regarding...
Can you state your address, sir,
Oh,
for the record?
It's, I own a property at 128 Bloomingdale, which is down the street from the...
Where do you reside?
I reside at 335 South Wayne.
I'm sorry, there.
335 South Wayne Avenue.
Now, what's the issue on standing here, John?
And how far away from the subject property are you?
Well, 128 Bloomingdale, we received notice on the hearing.
So we own this property.
Yeah, it's what...
You're within the 500 feet.
Yes, our property is West Wayne and Bloomingdale.
Mr. Gemmer, if you would confine your remarks to the legal argument on the narrow issue that we're discussing.
It'll be very brief and
Thank you.
very much so. Regarding Mr. Cutler's question regarding the lot area as well as the interpretation specifically that the impervious shouldn't, or that the right-of-way shouldn't be included in the impervious calculation, if you look at the zoning definitions beyond impervious surface, the next two beyond that, which are interior lot and interior lot development, interior lot is just the definition about having the narrow segment that gets you to the bulk of your property. But more importantly, the interior lot development, I will point to the second sentence in there, which states, the area of any portion of the access between the street and the interior lot line that is less than the required width for the zoning district cannot be included in determining the lot area. And the definition before talks about the 20 feet minimum.
Is this property an interior lot?
No, but my point being, in terms of this definition, it's saying that you don't include the portion between the street and the interior lot line, which would be consistent with the argument that you didn't include the street to begin with, because it doesn't address that portion of the lot. It's only saying you have to exclude the portion of for the narrow portion there, and there's no contemplation of what you have to do with the street because that's already considered not part of it.
That it? Is that your argument?
That's all I.
Thank you, sir.
Please.
A couple of points, I'll make it very brief, in response to what Mr. Nelson has offered this evening. First, I think it's completely irrelevant what a property owner believes they own or do not own. They own what they own, and that's the way it is. And in Radnor, they own to the center line of the road.
They own what the deed says they own.
That's correct. Whether they realize it or not and take advantage of it or not is completely irrelevant. I think it's also not accurate to suggest that an interpretation is absurd when it's been made by 4 zoning officers and 3 township engineers for the past 20 years. While you may suggest that's not relevant, case law states that when interpreting an ordinance, established practice may be taken into consideration. And that's the Kind case, Mr. Ryan.
Yes, I'm aware of that, but it's may be taken. It's not has
That's
to be.
correct.
We haven't really had any testimony on established practice.
I'm simply responding to a
But
statement
we haven't
that our
had any.
interpretation is absurd.
Truth of the matter is, the people that are testifying haven't been around very long, and so we really don't have any way of doing it. You don't have any witness to put on that.
I'm happy to put a witness on if you'd like to hear that
Not
testimony.
as established practice of the township, you don't.
He's been practicing in the township for 20 years.
And I've been living here a hell of a lot more than that, and I can't say that I could testify on that subject. So I don't think that's really evidence.
I have to respectfully disagree, only because he's submitted plans and had reviews and created lots as an engineer.
A lot of us have.
I'm sorry?
A lot of us have. But we don't know what the practice was for the last 20 years.
Well, do you have further argument on the legal issue?
And I guess the last argument I would make is I think that we need to focus on the definition of a lot and what the language in the ordinance states. Mr. Nelson suggested that it somewhere states in there that you do not include the street right-of-way. I'm happy to read the definition into the record. There is no mention of what you include and do not include with respect to street right-of-way. Is it beneficial to read it into the record?
And are you reading from where?
From the township zoning ordinance?
No, we all have it in front of us.
No, we haven't.
And we've
So
taken notice
I think
of it.
to suggest that the language is clear, that you do not include the street right-of-way, is a fallacy and not something that should be taken as fact, because the language of the ordinance speaks for itself, and it is silent on this issue.
Mr. Falcone,
Yes,
this
sir.
is not a legal question. By the township's interpretation, what level of hardship is the applicant facing?
We're not discussing the zoning now, Cora.
No.
We're not,
That's why I said
but we're not
it is-
talking about a variance. No evidence has been put on.
I'm trying to find
I
out,
think he just wants to know what the impact is.
Yeah,
We lose
the
about
impact.
5,000 square feet of developable area on our lot.
Okay. Another
impervious.
another reason I am saying, because I was watching this Monday's Township Board of Commissioners meeting till 11:30 or 12.
So was I.
The main issue was impervious surface.
Yes.
Okay, and our chairman was always catching on that issue for any development application. So this comes within that purview.
Yes, sir.
Okay, so you please discuss your point, how it is going to impact your development, if there is any alternative to accept I'm not saying you have to accept in total the interpretation, at least change that situation so that that interpretation will not be a burden on you.
It's not really possible based on the location of this lot. It's a corner lot that is split zoned. So you have a large portion in the back, which is R5, and then you have a portion up front, which is C1. And per the township, we have to look at the districts separately. Even though it's one property, we split the zone. We are looking specifically at the C1 requirements. Just in that district alone, the township's interpretation adds 5,000 square feet of impervious surface. Is that correct? we would lose that amount from our calculations. It would make our proposal and really any significant change to that project, to that property, very difficult. Is there a way to develop it? I'm sure. We're not claiming a taking. It would just make real development of the back piece and the front piece very difficult. Now, it's also relevant. I don't think we want to get into the discussion of the plan, so I won't, but there are other issues with that plan in the lot, the corner lot and so forth, the access which currently goes into the center of the road. But I think the language of the ordinance is the language of the ordinance, irrespective of our plan. This is an interpretation made on this language. And we could have any plan in this township, and we still believe the language states what it states, and that it is in a C district, in the C1 district, you do not net out the right-of-way when calculating lot area and your lot.
Okay.
That's the premise under which we've made our appeal. And again, we believe it's not necessarily tied to our application. It is a general interpretation which has now been made and will impact every application.
Okay.
Thank you.
Mr. Chairman, could I just say one thing?
Go ahead.
That when a new interpretation is enacted by the township, as was done in this case a month or two ago, there was no notice to the property owner or any other property owners in the township that might be similarly affected. This is not a fair or reasonable or legal act on the part of the township to change the interpretation that from what it has existed
Well,
for 20 years or more.
Had no
We've had no
testimony to that
testimony on
effect,
that point yet,
Harry.
so.
Okay.
That case hasn't been
It's
made.
available.
The
if we
case
get to
hasn't
that
been
point.
made that this is the way it's been interpreted for 20 years.
Because we're just limiting this discussion
Right.
to the narrow issue of the legal interpretation of it.
But do you have a former township official who could testify to that? Should we get to the next issue?
No, we
No,
should.
hopefully,
We're gonna
resolve on this issue.
Yeah.
Okay.
We're gonna break for executive session. We get some guidance from our solicitor.
medical care and things like that.
That's right.
We should be deciding the great issues of the day, shouldn't we?
Doesn't this count as one of those issues? You had some
Okay.
comments you wanted to share, Nora?
Here's where we come down on this. And realizing now that this is not necessarily a position on our part of whether things should be one way or the other. Our job is really very narrow. We have specific sections of a statute, and we have to deal with what it says, whether it's clear in what it says or it's ambiguous, and if it's ambiguous, how to resolve the ambiguity. This ordinance does not define lot area. A lot of zoning ordinances do, and sometimes they define it different ways for different purposes. Just as in this case, Radnor's saldo defines it an unusual way to deal with a particular purpose. This definition of lot really doesn't say how you decide what the bounds of a lot are, nor really should it, because the land you get when you get a deed is determined by law and not by a zoning ordinance. And you get what you get. And by the way, it doesn't relate to how it's described, whether it's described to the side or to the center line or anything else. If in fact you own to the center line, you get to the center line even if it's described to the side in the deed. If you own to the other side, you get to the other side even if it's described to the sideline of the ordinance. That's as a matter of case law. If it's a street or a public alley or any one of a number of thoroughfares. So a lot is a lot. This definition of lot really is just to distinguish it from some other lot. It's this lot, not that lot, because it's a parcel of land on which you have a principal building or could build one. It's not something that defines what the meets and bounds are. So if in fact you own to the side of the street or the center of the street or whatever, that's what you own. And that is your lot area, even though this doesn't define what lot area is. If it had defined it, we could be interpreting that, but we don't have to. It defines impervious surfaces. We all know what they are, but then it says this definition shall not include any portion of a lot located within the street. The definition of street includes the entire right-of-way, including the cartway, a sidewalk if there is any, could be shade trees there, grass. All of that is in the definition of street, the way this ordinance defines it. That means that stuff is not impervious and can't be treated as impervious for any purpose under this ordinance. But it has nothing to do with saying what you own. You own what you own. And if you have X number of acres, that's what you have. We think at the very least there's an ambiguity here. And if the township meant to say, we will not deal with the area of the street right away for the purposes of computing impervious surface, it could say that. It could have said, we will take the area net of the right-of-way to determine the impervious surface ratio. Or any other ratio, building coverage ratio, any other ratio. But it didn't do that. So at the very least, we find that there's an ambiguity, and our understanding...
We're not voting yet, we're just talking individually.
This is me saying it, then we'll ask if everyone agrees and what the effect of that is. So it's our understanding from our solicitor, and I'll ask him to confirm that if in fact there is an ambiguity in this ordinance, that it must be interpreted in a way that does not restrict development and favors the applicant, because the ambiguity is on the township as the drafter and promulgator of the provision. That's my understanding of where we are. Does everyone agree on that?
I agree that there's an ambiguity in the ordinance.
And Cora, you agree? I agree. Your mic's not on.
Mike.
Okay. I concur with that analysis.
Mr. Solicitor, will you confirm for us the effect of an ambiguity here? And
No, I will confirm a couple of things. First, to the extent there's a genuine ambiguity as opposed to creative lawyering manufactured ambiguity, the ambiguity by statute and by case law is resolved in favor of the applicant. There are not a huge number of areas of Pennsylvania zoning law that are crystal clear, but that one is. I think on this record, I have a real problem avoiding, much as I would like to do it, the conclusion that there is an ambiguity. I notice that the definition of impervious surfaces, which excludes areas within the street, is a definition of surfaces, not of coverage ratio. It's not a coverage. Would I see that, read in the, it should be, in the favor of the applicant, is you can't add the street into, or the sidewalks within the street right-of-way into the applicant's land, but not that you can't use pervious areas within the street. And if it was supposed to be affect the coverage ratio, it should have been drafted differently. That's not how it's drafted. So on this record, I don't see crystal clarity either way, to be candid. But I think there's a very strong position for a genuine, legitimate, non-lawyer manufactured ambiguity here. And if the board concurs with that, then my advice to the board is they have to rule in favor of the applicant under established Pennsylvania law and under the MPC.
Okay. Do we have a motion?
Yes, I move that we overrule the determination of the township officer and that we grant the relief requested by the applicant.
Cora?
Yeah, I concur with Nick's analysis.
I think we should, if that's what the vote's going to be, it should be clarified that we're simply reversing the zoning officer, and since we don't need to go further, we aren't going further.
Okay.
Okay. But it would sure be a good idea if somebody would reconsider these provisions and these definitions sometime.
Okay.
Off the record.
Thank you. Relief is granted, and we're adjourned. Thank you.